good discussions, and I'm sure that that will continue in this panel as well. Just some housekeeping, if everybody could keep your video off and your microphone muted, it will help the session to run a little bit more smoothly. The way that the session will proceed, each speaker will have 10 minutes to speak before we hand over to our discussant. And we would ask you if you could try as much as possible to stick to time, because we have a keynote address coming up at 4:30 and we want to make time for discussion at the end of this. As well as our panellists today, we're delighted to welcome Professor Colin Harvey as our discussant. Professor Harvey is a Professor of Human Rights at the School of Law, and he is no stranger to discussions on equality and human rights. So I'm sure that his insights will be most welcome today, and we're looking forward to a great discussion coming up. So thank you, Colin, for joining us for this session.
Thank you, Gillian.
No problem. Without further ado then, I will hand over to our first panellist, Fabrizio de Lemos, who is joining us all the way from Brazil, where I'm sure it is much warmer than it is here in Belfast. So Fabrizio, over to you.
So, hello everyone. Can you all hear me? Yes.
Yes, we can hear you.
Okay. Thank you for the introduction. And yes, the AC is on. Right now, it's very hot here in Brazil, but it's okay for us. So, as Gillian stated, my name is Fabrizio Lemos. I'm a PhD candidate at the Federal University of Rio Grande do Sul in Brazil, and I'm here to share with you my thoughts on the ineptitude of international law in addressing inequalities in the making of international law. By the usage of language, we can include or exclude something or someone from rights. This is not a new theme. Critical legal studies, critical race theory, and feminism, for example, just to name a few, all think about how language and concepts are used to include or exclude persons or minorities from rights, and also to perpetuate hegemonical power and political structures. So the main topic I use in my paper is the way international law is made and how the barrier of language is used to exclude thinkers from, especially the Global South, from important discussions and decisions on subjects of international law that affects all human beings. This may result in structural injustice because the rules are mostly by English-speaking, which has come to be regarded as lingua franca of international law, as Antia Roberts calls it. We can also see these kinds of inequities in international organizations such as the UN, which not only does not have Portuguese as an official language, but also Brazilian nationals are highly underrepresented in the staff of the organization. In terms of the discipline of international law here in Brazil, the subject has become mandatory only in 1994. However, in the beginning, there was mainly scholars who have been abroad on PhD or postdoc positions in the global north and have returned to teach what we now call mainstream international law. The teaching of the team mostly based in terms of textbooks and from the global north, such as the ones from Shaw or Brownlee's. And however, since 2000 or so, there's a new wave of scholars here who are now preoccupied in North-South relations, decolonial thinking, 12 perspectives, and other critical thinking in international law. And because of that, in terms of doctrine, especially in terms of Brazil and Latin America, there's a growing concern on the studying and reading and discussing Latin American and Global South authors. And professors such as Luis Eslava, B.S. Chimney, and Professor Rajagopal, who are, by the way, located in positions in institutions in the Global North, but also professors like Antoni Young, Fabio Morosini, Fernanda Bragato, Michelle Badin, Paola Alvarado, Enrique Pietro Rios, Liliana Obregon, and many others here from Latin America and Brazil. But Brazilians also intend to occupy spaces in the global north, such as this one we're having right now, to raise awareness on other kinds of good scholarly works, such as in international economic law, international trade law, and also on the philosophy of international law. And in terms of international human rights law, I was really glad to see on the panel on climate change that we had earlier mentions on the Inter-American Court of Human Rights and Inter-American Commission on Human Rights, which are important locus of discussions on environmental rights. In terms of Latin America, there's an integrated college of international lawyers who are writing mostly in Spanish and Portuguese, but also in English, on matters of the critical teaching of international law here in Latin America, and also on matters of decolonial thinking and its consequences on the making of international law. There's a group of scholars here called Gillian, based on Bogota, Colombia, of highly qualified professors who are able to adequately think in terms of a Latin American perspective on international law. And Latin America has played an important role in terms of economic, social, and cultural rights, and its inclusion on the Universal Declaration of Human Rights, for example. As you may well know, the American Declaration of Human Rights is 8 months older than the Universal Declaration, and the writing of some articles is very similar. The other side of this story is that scholars from the global north are not able to access the works of Latin American international scholars, mainly because of the barrier of language. We as Global South students and professionals are also not able to publish on highly qualified journals because of the barrier of language. Even if we speak English adequately, the grammar structure is different and the academic language in English is far more objective than what Brazilians and other Latin American countries are used to. Since Global North scholars are mainly only English-speaking professionals, and you may well correct me on this one, there's no communication between these two hemispheres of the globe, resulting in a highly unequal, invisible college of global international lawyers. In conclusion, I'm very grateful for being here today to express this concern on what I think it's a necessary issue to discuss with scholars from the global north, such as yourselves. And I emphasize that this is mainly a concern of my concern, and I'm very open on discussing the implications of these ideas with you. I'm looking forward for your comments, questions, and thoughts on this matter, and thanks very much for your time.
Thank you very much, really, really interesting presentation, and just giving us a bit of an insight into perceptions of international law from Latin America. I find it very interesting just in relation to my own research, and I'm sure that others here will too, so we'll look forward to the discussion later. Moving on to our next panelist, we have Colin Barry, who's joining us from NUI Galway, and she is going to speak about disability in direct provision and the EU, the recast Reception Conditions Directive. So Colin, I will hand the floor to you. Colin, can you hear us?
Hello.
Brilliant.
Just trying to share my...
Ah, yes, we can see you now.
It's not letting me upload it for some reason.
I think I have your presentation, so would you like me to, I can, just bear with me 1 second. The technology, so let me see, Kane. Okay. So that should be it coming now. If you just want to press tech control, then you should be able to control the slides.
So good afternoon, everybody. Today I'm going to talk about disability in direct provision and the EU Recast Reception Conditions Directive and the importance of building a vulnerability assessment tool. So direct provision is a system in Ireland that has been in place for over 21 years to accommodate and provide basic services for asylum seekers seeking international protection in Ireland. It has been strongly criticised since its beginning in 1999 when it was introduced on an emergency meant to be short-term basis. Conditions within direct provision are argued to very much violate human rights, and many reports and state reports to the state and NGO commentaries on the system have been very critical. For example, the communal living situations, which are very overcrowded. Adults get 80 euros per week, and per child it's 28.80 a week. And in May 2020, the Day report revealed there were 7,700 individuals in the asylum system currently. There are 44 direct provision centres around Ireland, often in remote locations, as well as 33 emergency accommodation centres, which have been used more frequently since the capacity of direct provision has been very full since 2018. And as discussed, the criticisms of the human rights violations continue, with the recent Day report recommending very big changes, as well as an overhaul of how international protection applicants are accommodated going forward. So when referring to disability, I'm using the CRPD non-exhaustive framing of disability. Today is the International Day of Persons with Disabilities, so this is timely. So Article 1 of the CRPD frames it as persons with disabilities include those who have long-term physical, mental, intellectual or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. So disability within direct provision is very much a very invisible population group with very little attention paid, either within the mechanisms of the Irish international protection system or disability services within Ireland. All asylum seekers, while the earlier mentions of vulnerability in John's presentation brings up lots of debate, can be argued to be a very vulnerable population due to the pre-mentioned difficult situations that they're living in, often for protracted periods of time in direct provision. And disabled asylum seekers, particularly with additional barriers, would be even more vulnerable. In relation to asylum seekers, Stramer says that persons with disabilities may require particular protection. And disability-related needs are not recognised or accommodated within the system. And it's an area that is going to require a huge amount of activity as changes are brought into how the vulnerability assessment tool hopefully will be developed. There are many access issues, including the direct provision centres themselves being very old buildings, often convents, old hotels, holiday camps that are not accessible to disabled people's needs, and also the remote nature of many of them cause barriers to health and service utilisation for disability services. When talking today about inequality in the panel, we need to look at the intersectional discrimination in relation to discrimination. This group of people will often be coming from many varied traumatic backgrounds. People may have had very much negative experiences of how their disability has been perceived in their home countries. Disability could have happened and been acquired on the transit journey to Ireland. There could have been disability acquired while within direct provision. And if you are a victim of trafficking who's in direct provision, an older disabled person, an unaccompanied minor who has got a disability, who has aged out. If you are a disabled single parent with a child with a disability, or you may have invisible disabilities, multiple disabilities, all of these barriers and extra intersections of discrimination add difficulty to your daily life. And disabled asylum seekers, according to Kane, are at a heightened risk of violence, including domestic violence and discrimination. Mental health is another area that needs to be spoken about, and it could be a whole presentation. Direct provision has been argued to exacerbate mental health difficulties for individuals in direct provision, including child asylum seekers. And there is no data at all collected in relation to disability within the direct provision system since 1999. It is something that really needs to be changed. Ferry asserts that the lack of data in disability reflects the lack of awareness of the issues relating to migration and asylum and within institutions. So when referring to the vulnerability assessment tool in the recast conditions directive, which I'll describe in the next slide, as John had mentioned, vulnerability earlier in his presentation, vulnerability is a contested and very loaded topic, and we need to be aware that the concept is contested and that disability does not necessarily always equate to vulnerability. Currently talking about the RCD, the provision about vulnerability assessments mean that vulnerability is spoken about a lot, but not all disabled people are vulnerable, and that is something that we really need to be clear about. Because of the group-based view of vulnerability that is going to be described in the RCD, there is a worry that it can ascribe vulnerability to all members of a vulnerable group automatically without taking into view the individual context of that person. And so that is something to be very cautious about. And it also obviously has the potential then to reinforce negative stereotypes and additional stigma related to disability. So the Recast Reception Conditions Directive was adopted in the EU in 2013 as part of the Common European Asylum System. Ireland had opted out of the RCD until a very important case in the Irish Supreme Court in 2017, which was the NVH versus the Minister for Justice and Equality and Others case. This Supreme Court case ruled that the absolute prohibition of asylum seekers to work in Ireland was unconstitutional, and Ireland then reformed the law to allow a very limited right to work for asylum seekers. And then they decided to opt into the RCD in full at that stage. Ireland transposed the RCD to legislation called the European Communities Reception Conditions Regulation 2018 on January the 23rd, and it became operational on the 30th of June in 2018. Specifically to disabled people and other vulnerable groups is the obligation to develop a vulnerability assessment tool. Article 2 defines a vulnerable person as who is in need of special guarantee in order to benefit from the rights and comply with obligations provided for in this directive. Article 21 sets out the groups. I won't list them all now because we're short on time. And you can see I've highlighted disabled people there as one of those special vulnerable groups that requires access to a vulnerability assessment tool. So currently, 2 years after transposition of the RCD, unfortunately, there still is no vulnerability assessment tool that has been developed or implemented. The regulations state that vulnerability assessment tool should occur or be available within 30 days of an international protection application being lodged. In December 2009, when Ireland was before the Committee of Elimination of Racial Discriminations Committee for its state review, when questioned by the committee about the vulnerability assessment tool and disabled asylum seekers, the Irish state replied that they would be developing the vulnerability assessment tool in March 2020. However, due to COVID, there may have been a delay. Unfortunately, it has been mentioned previously, and there has not been any implementation to date. And the third concluding observation report in January 2020 recommended the Irish state introduce a comprehensive vulnerability assessment mechanism for early identification of asylum seekers with special needs. And again, COVID-19 exposed the heightened vulnerability of all disabled people everywhere. Certain disabled people will be more predisposed due to certain medical conditions, perhaps, to infection, and COVID-19 is a huge risk depending on your own personal situation health-wise. It also, in direct provision, caused huge distress to the general direct provision community because people couldn't abide with such crowded living situations with the government rules on social distancing, for example, and disabled people were at increased risk as a result of living in direct provision during this pandemic, causing grave concern. So in conclusion, the vulnerability assessment is a legal tool that is a requirement mandated by the transposed legislation. It's not a choice issue, it needs to be developed. Assessment of barriers to identifying disabled people, including invisible disabilities and stigmas that might prevent people from self-disclosing disabilities, such as negative cultural associations. All of those issues need to be taken into account and mapped when developing this vulnerability tool. And the intersectional impacts of inequality and discrimination that disabled asylum seekers face need to be really known and accounted for to be able to be mitigated. It needs to be able to be accessible to the 7,700 asylum seekers currently in the system who have never had a vulnerability assessment undertaken. And it also needs to be available on an ongoing basis so that if people's situations change, or if they weren't in a position at the start when they come to a reception centre before a direct provision centre, that they can do that at a later date. And the disability data collection is very important, that proper best practice data is collected so we know the situation of what disability there are on a level of need, and it may require rapid needs assessments in this really important time when the tool is to be developed. Ireland will also present its first state report to the CRPD committee in early 2020, and asylum seekers with disabilities are equally involved in CRPD activities and should have the protection of that convention and will need to be accounted for by the state. The optional protocol will be ratified when the state presents its first report, and this will allow for future individual complaints to be made to the committee. A human rights CRPD focus needs to be a key part of the implementation and building of the tool and assessment process the whole way through. And thank you very much for the time. Thank you.
Thank you very much, Colin, for that very comprehensive overview and just highlighting some of the issues there through the lens of disability. Very interesting indeed, so thank you. We'll now hand over to our third and final panelist of this panel, Rihanna Tuljanat from the University of Eastern Finland. And I believe that I also have your slides, so I will just bring them up on the screen now. And meanwhile, if you want to unmute yourself and turn your video on if you can, then we can get going. So hopefully these are your slides that are coming up.
1 second. Yeah, that's fine.
Brilliant. So if you just want to press Tech Control at the top, then you'll be able to control them.
Yeah. That's great. Thank you. Hi, everyone. I'm Raihana Tuljanith from a doctoral researcher at the University of Eastern Finland. Today, I will be presenting a part of my PhD, so it's a working paper, and I'm focusing on the relationship between gender-based adaptation and socioeconomic resilience under the transnational climate regime. So I'm basically more in line with the climate guys who just presented all bits in here. Firstly, I want to say this is a very important issue because, as we know, climate change is non-discriminatory, so it affects everyone. However, some groups are more vulnerable than others, and rural women are, as a group, are more vulnerable than rural men, for example, due to their lesser socioeconomic and political standings. However, these vulnerabilities again differ according to region or social. For instance, in Bangladesh, climate change directly does affect a rural women's food and livelihood insecurities, and it does exacerbate their existing social injustices. On the other hand, another part of my research, which focuses on the Finnish Arctic, economic transformation of the Arctic, accelerated by climate change, now has given rise to a biased focus on male-dominated economic sectors, and this has triggered inadequate gender responsiveness in the Finnish Arctic. However, at the same time, rural women can also play a very key role in adaptation because of their activities at the household and community levels, and through enhancing their resilience, rural women can actively participate, plan, and implement effective adaptation to climate change. And effective adaptation measures that can address climate impacts of rural women require integration of gender equality at all levels. And this is where law comes into play, because law can make use of its, for instance, multi-level structure and establish linkages between relevant factors and fill in the governance gap. So with that in mind, firstly, I wanted to just bring through what the Intergovernmental Panel on Climate Change, IPCC, has defined adaptation as just as a process of adjustment to actual or expected climate and its effects. And the effectiveness of adaptation strategies in a social system rely on the community's adaptive capacity and its acute level of vulnerability, and strengthening its resilience of social and ecological system is classified as a essential goal of planned adaptation. Oops, sorry, I totally forgot to do that. My bad, sorry. Yeah, so we are here at the, right, okay. So in general, adaptation actions can reduce vulnerability and increase resilience to current and projected climate risks at the national, regional, and community levels. And gender-based adaptation, for instance, can integrate gender-sensitive approaches and tools for understanding and assessing impacts, vulnerability, and adaptation to climate change, and thereby, in turn, enhancing climate resilience. So as such, my research is reviewing on gender considerations within existing climate frameworks at the international, supranational, and regional level. So first, we look into the gender considerations at the international climate regime, which is the United Nations Framework Convention on Climate Change. The gender issues within the UNFCCC has been integrated in recent years, and the UNFCCC has also emphasized on the importance of taking gender into account into all sorts of climate action and policies. There are several mentions of gender equality, for instance, in the Paris Agreement, in the preamble, and several other articles, such as Article 7, which focuses specifically on adaptation, and Article 11, which focuses on on capacity. And all of these clauses acknowledges and reiterates the role of effective participation of gender and the need to kind of endow the skills to both men and women. Then the Catalyst Climate Package, which was developed in 2018, also makes some reference to gender responsiveness and most importantly, emphasis on the need to provide responsive adaptation under the UNFCCC's adaptation communication, and the national adaptation plan process that is within the UNFCCC, where the parties have to produce, is also a critical tool because it provides the parties an opportunity to connect gender equality and climate change and identify the specific needs of that country, and also develop and implement strategies and programs that are gender sensitive and participatory specifically for that region. Also, the UNFCCC's Enhanced Lima Work Program on Gender and its Gender Action Plan focuses on capacity building efforts and in mainstreaming gender in national climate policies and adaptation plans. And next, we look into gender considerations within the EU climate policy, which is relevant to my research because of my one of my case studies on the Finnish Arctic. So the EU, along with all its member states, is also a party to an UNFCCC and has commitments under the Paris Agreement. And it also plays a key role in trying to reach agreement on global climate targets. In the EU, the 8th EU Environmental Action Programme, it's a strategic instrument that will be guiding EU environmental policy, and the 8th one is to be adopted in 2021. It doesn't specifically mention any gender issues as such. However, the European Parliament's resolution in January 2018, it does acknowledge the possibility of tackling the weaker socioeconomic position of women and therefore strengthening their resilience to climate change. It is very important because this resolution also maintains that women can only be empowered in rural areas. The empowerment of rural women is critical because it has a connection to access to land and sustainable farming methods, and that can also build climate resilience. The EU also has a number of other activities that, for instance, support socio-economic development and cooperation in the Arctic regions while maintaining environmental regulations. But in general, the EU's efforts to address gender equality and climate change has been criticized to be parallel to each other, whereas for it to be more effective, it should be combined into an integrated approach. And it has also been criticized that a gender-responsive outlook is not exercised into all aspects and all stages of EU climate governance and decision-making. In my research, we also look into oops, sorry, I keep on forgetting to the slides. Also look into gender considerations within the Arctic Council's guiding principle. Just wanted to make a point that at the regional level, climate action in the Finnish Arctic is supported by the Arctic Council, and the Arctic Council is an intergovernmental forum for Arctic cooperation, but it does have a strong focus on environmental protection. Now the Arctic Council published the Arctic Resilience Action Framework in 2016, and that provides several guiding principles to increase the overall adaptive capacity of Arctic communities, and it suggests in building upon existing global, regional and national frameworks that can empower the Arctic communities, and also it states that effective climate adaptation measures can help build resilience, and actions fostering resilience can build the capacity to adapt. However, all of this requires a gender balance and gender responsive approach. And the Arctic Council Sustainable Development Working Group also contributes to climate resilience in the Arctic by promoting projects such as the Arctic Council's Gender Equality in the Arctic Project, which recognizes all sorts of gender-based factors that negatively affect the climate resilience of Arctic communities. And lastly, look into a gendered approach on climate resilience and other international instruments. So for instance, the Sustainable Development Goals, it also promotes mechanism that focuses on women and other marginalized communities and establishes an integral linkage between the economic, social, and environmental developments and opportunities to build climate resilience. And the UN Climate Resilience Initiative, for instance, are also engaging in partnerships to promote a common ground for climate resilience while encouraging a gender-sensitive knowledge and innovation to support decisions for climate resilience. So in conclusion, as I said in the beginning, this is a working paper. So for now, what has come up is that, of course, there's no set, just like adaptation policies, there's no set definition of socioeconomic resilience, and factors that affect socioeconomic resilience of rural women vary on regional, geographical, and socio-cultural factors. However, in general, the gender-based adaptation framework strategies and policies at the international, supranational, and regional level all seek to uphold and strengthen resilience of the target groups on paper. However, whether these framework strategies and policies enhance the socioeconomic resilience of rural women and women in general in practice is something that needs to be determined still. I'm really sorry, I realize I keep on forgetting changing my slides, but if you have any questions, I'm more than happy to answer. So thank you so much for your time.
Thank you so much, and no worries at all about the slides. Really, really interesting presentation on another really timely topic. So 3 very interesting presentations on different aspects of inequalities. And so I'd now like to give the floor to Professor Colin Harvey. Colin, if you want to unmute yourself and turn your video on, we'd love to hear your thoughts.
Okay, good afternoon, everyone. Good afternoon. Can you hear me okay there? Hopefully.
Yeah, we can hear you.
Okay, just like to thank all the panelists for really excellent presentations, and I'd also like to commend again the Research Network for organising the event today and getting people together, even if it's only in this virtual world that we're currently in. What I thought it might be useful for me to do was just to mention some points about the individual presentations, which I thought were excellent. So just well done, and a virtual round of applause for everyone there, and then draw out some themes that might be useful for discussion. I'll try and keep it as short as I can. In terms of the different presentations, Fabrizio really focusing on questions of language and exclusion and inclusion, particularly I think what is a really important theme, which is the exclusion of the global south in terms of international legal scholarship and debate, something I think we all need to be conscious of and pay attention to and actually do something about, really from a critical international legal perspective, drawing to our attention, I think very, very helpfully indeed, a Latin American perspective in terms of international law, giving examples, but also highlighting, I think, something that we really need to think a lot more about who is included and who is excluded, and the voices that are at the table and the voices that are not at the table, particularly when we're thinking about issues of the making of international law has been pointed out. Keelan really highlighting questions around direct provision with a focus on disability in particular, and really the sense in which I think that's been a neglected issue in the context of direct provision. So, and again, it's great to see a project that is doing something about that, making visible what was, invisible in terms of the current research, looking at the Convention on the Rights of Persons with Disabilities and its application in the Irish context, thinking about the contested nature of the concept of vulnerability, which I think is something that's relevant across a range of different research projects at the moment, and it was interesting to hear the perspective on that. Looking at the directive, looking at what's there, but obviously enough the problems that remain in terms of unaddressed needs and the work that still needs to be done, and that came out really, really very clearly indeed from the presentation. So well done. Rahana Yul, highlighting questions around climate change and the gendered impact, particularly in relation to rural women, issues around adaptation and resilience, questions around gender integration and responsiveness. And, you know, I think what that brought out to me again very, very clearly and well is all the talk about gender mainstreaming, but to what extent that has all been made real in practice. I think so. Both very interesting perspective, honing in on the climate change conversation and thinking about the gendered impacts, gendered perspectives, and the sense in which that has really been or not been integrated in law, policy and practice. So brilliant presentations, really, really clear. Did a great job in a short period of time, much better than I'm doing in my transcribbled notes. Feedback to you all. In terms of the themes to draw out for discussion, which I think all the presentations made me think about questions of exclusion and inclusion. You know, I think in the debates around human rights law, often the questions of not who's at the table, but who's not at the table. The narratives that are dominant, the narratives that are rendered invisible by the existing structures and legal frameworks and dominant approaches. And all three presentations brought that out brilliantly well in their different contexts. Questions around, seems to me, you know, basic questions around linguistic exclusion, the way in which language can include and exclude in terms of participation, the question of the systemic, structural and systematic exclusion of global South scholars in the wider scholarly community is, let me be very, very clear, shameful. Why is it shameful? Because for all the talk about global conversations and discussions, huge swathes of the modern globe, huge swathes of global academia are effectively rendered excluded from the current conversation. And we need to all be concerned about that and think about how we address it in a practical way. Because if we don't, we're not having a global conversation, for all the fine words that international legal scholars like to throw on the table. The treatment of asylum seekers, I think, in the questions around, which are really emerging is not the right word, but there's been a lack of focus on disability in the whole debate around refugees and asylum seekers. And it was really great to see the convention disability focus being brought to bear on the question of direct provision. I know there's more work being done on that. I know it's been rendered more visible than it was, but it was great to see that perspective, that work being brought to bear on this, the vulnerability concept exposed, and questions around, you know, the general questions that, you know, we spend most of our lives thinking about in terms of human rights, which is compliance. You know, we all know, and it's a basic point to make, and we're fed up saying it, but we spend a lot of our lives, you know, putting some of the legal instruments up on slides, but wondering why they're not working in practice or how to make them work in practice. And in terms of direct provision in Ireland, that's a specific point, but it's a general point that we're all struggling with. You know, in the theme for our session is addressing inequalities. Every conference or event I go to on equality, data collection comes up at every event. Whatever we're talking about, somebody or the point will often be made that we don't have appropriate data to measure the stuff that we need to measure in order to make an empirically informed assessment. So disaggregated data that allows us to speak authoritatively about whether rights are being implemented and needs met. But on inequality, it just comes up all the time. We're just not collecting the information needed to think about impact. And of course, in particular, gendered impacts and the continuation of gender inequality in all the areas that we're thinking about. Bringing that front and center to the debate about climate change and the differential impacts. Particularly, we've heard about the impact on rural women and the debates there. But again, it seems to me that compliance and effectiveness keep arising. You know, we're all at this point, I think, probably, you know, we've heard so much about mainstreaming, gender integration, gender responsiveness, whatever language we use in this concept, and we see the language there, but how effective is it? You know, yes, the language is making its way into the appropriate documentation in terms of climate justice, but is it having the necessary impact and effect? Is a gender perspective being fully implemented in practice? And I think we saw some of that there. Questions around responsiveness as well, and resilience. Ultimately, you know, brilliant presentations, all raising themes that we're all grappling with: inequality and human rights, and thinking about international law. Questions around inclusion, exclusion, visibility, invisibility, gendered impacts, people who are at the table, people are not at the table. How can we make some of the rules that are there mean something in practice? Are we measuring the right things? And what would it mean, even if we were, in terms of getting some of these tools implemented in practical context? So just to thank the network, those are my scribbled thoughts listening to those presentations as I heard. I'm sure I have not done justice to you all, your wonderful, concise presentations this afternoon. I'm not being wonderful or concise here. So again, so look forward to the discussion. Very much appreciate the invitation. Brilliant work, absolutely central and key points, and look forward to hearing what others have to say in the group. And I learned a lot as well, listening to what you had to say. So I'm going to take away things you've said. So these things aren't just one-off events. So look forward to maybe talking to a few beyond this now as well. So thank you again. Okay.
Thanks so much, Colin. Really, really interesting insights and very, very helpful. We've got a bit of time now for our panelists to maybe respond on some of the questions that you raised and some of your comments. So I maybe just take in order that the presenters presented. So if we hand over to Fabrizio first.
Okay, thanks, Gillian. Thanks a lot for your comments, Professor Colin. This is highly. I was kind of it was maybe not an emotional time for me, but it was surprising to see how you call it shameful that we are as Global South scholars are not included in the Global North conferences or symposiums, even though we as international lawyers or international law scholars, we are able to speak or to present papers in terms of symposiums like this in the Global North. And this is a good thing that came in 2020 because we are able to do this kind of things from my office right here. So it's great to see this. But we are not, I think so, we're not as used to publishing, mainly in terms of highly qualified journals there in the Global North. And we see professors, mainly, there was a research here in Brazil 2 years ago that stated that from 45 professors in doctorates and masters in law here in international law, 45 of them went to a PhD or a postdoc position in the Global North. Not a single one went to Latin America or African or Asian countries to study. All of them went to France, to Netherlands, to the United States, and to England, and so on. So this is a kind of, I don't know, you have to wear it like a badge to be an international law scholar here, you have to go to the global north so you can say or you can speak in terms of international law here in Brazil. And this is something that since 2000s or 2000 maybe something, we are trying to change here in order to see, and this is an important step, or this is an important role for us in the global south. So I would like to thank you very much for your comments and thoughts on the matter. Okay, thank you.
Thank you so much, Fabrizio, and it is really great that you are able to join us today, even from a few time zones away and a much better climate. So we're really happy to have you along, sharing that insight. Turning then to Colin, do you want to address some of the comments?
Yes, thank you, Professor Harvey. They were really brilliant comments. And I suppose in relation to disability indirect provision, disabled people aren't at the table and haven't been for 21 years. So disabled children, disabled adults, disabled older people, disabled people who have been victims of torture or trafficking. You know, I can't think of a more important issue within the international protection field. And yet, as you said, compliance, why hasn't the vulnerability assessment tool been delivered? But even prior to that, why hasn't this been on the agenda? There's other things around. You said that everything you said was brilliant, and I'll think about it further. And it was great to hear you speak on all of our presentations regarding the disaggregated data. It's just so important in relation to the specifics of disability, so that we can see and have a map of what the actual situation is, but also that we can be informed. We can have, as you said, empirical data to actually steer the future and what is going to be needed. For example, the recent Day report spoke about changing the system to a 3-month only stay in a reception centre and then move to owned or accommodation. We will need to know how many disabled people we're talking about to be able to provide accessible and universally designed accommodation for that to happen, and possibly other models rather than through the councils, city and county councils, as the Day report has suggested. There's other issues we have no idea about, really important issues like children who may be acting as carers unofficially to parents with disabilities and vice versa, issues around children with disabilities and where you live. If you're in a remote direct provision centre in Donegal compared to one in Cork, you may have less access to supports, you know, in disability services and really important early interventions. So thank you very much for having me here, and to the organisers. This is my first ever academic conference and I was terrified. You've made me all feel very welcome, and thank you very much. Thank you.
Thank you so much, Colin, and thank you for being with us all day. We've really enjoyed having you here, so very welcome. Finally, over to our last panelist, Rahana, over to you.
Yes, thank you, Professor Harvey, for your comments. And I agree with the whole. I mean, the more I read about it, the more in respect of climate change and gender, for instance, it's full of gender mainstreaming and gender responsiveness and this and that. But the fact remains that even with the international climate regime, it took around 20 years for just to put the word gender in a legal document with respect to climate change. And even then, the legal implications of it, you know, can be discussed as to if it really puts any responsibilities on the parties who have actually signed into that legal agreement. And also from many of these intergovernmental forums who are guiding with their strategies and policies and frameworks, most of the time it seems as if that gender and climate change are two separate issues which should be like both needs to be looked into, but no one really kind of thinks about an integrated approach, which is very important. You cannot have effective climate adaptation or effective climate action or even mitigation without taking into account vulnerable groups and women, or even all classes of like minority groups needs to be taken into account. But there seems to be a very I would say that of course it's developing now, that, you know, people are taking more into account. These intergovernmental forums, for instance, are taking these things more into account, but it's still a long way to go. So let's just hope that things are developing better. And of course, yeah. Thank you. And I just wanted to thank everyone, and I'm really sorry that I forgot to share the slides. So if anyone has any other questions for me, I'm more than happy to answer. Thank you.
Thank you so much. No, I think we're all getting to grips with presenting online, but it's no mean feat. So you did fantastically, and we're really glad to hear from you. I think it's just a product of 2020, all of the online presentations. So no, thank you so much, and really interesting insights, and made me think a lot about gender and climate change in a way that I hadn't done before. So brilliant. I'm just going to turn to the floor now. To the rest of the participants. If you do have questions, do put them into the chat. There is one here from Daniela, one of our own PhDs from the SRN team, who asks, Fabrizio, which do you think would be the impact of the Redial project for a greater participation of Latin Americas in international law and as a mechanism for the decolonization of international law? So Fabrizio, I don't know if you have any thoughts on that.
Hello, thanks Daniela for your question. I think just to clarify, the Redial project is a project that's based in 3 universities in Bogotá, Colombia, which Externado, Los Andes y Universidad de Rosario. And there are participants from Australia, from Melbourne University, from University of São Paulo, and myself from the Federal University of Rio Grande do Sul. I think there are some participants from Chile, from Peru, and other countries as well. I think we have a participant from Singapore. He's under the supervision of Anthony Yangi at the National University of Singapore. So the project is a project that states that we need to rethink the teaching of international law in Latin America to decolonize the teaching of international law. So the project has made some advancements. We had a conference in 2017. I joined in 2018. We had another one at University of Rosario last year, and there are 2 books written on the matter, which is called, the last one is Repensar la Educación en Derecho Internacional, Avances y Discusiones in 2019. So it's rethinking the education on international law in Latin America and the advances and discussions in 2019. I think it's a really good project, and you are all welcome to get to know it and to share if you want to with your colleagues. Okay, thank you.
Thanks so much. Yeah, really interesting. Something that I hadn't heard of before, so definitely will be looking into it and asking Daniela about that as well. We have a question which is probably also for Fabrizio here, so you're just going to keep your mic on, and that is from Anurag, saying scholarly spaces are often locked in the global north, as we and today's more remote format has allowed global south scholars to participate. Obviously, this is again a product of this year, but maybe is this something that you think should continue? Are these spaces useful to bring scholars together? To enter spaces that are tightly kept. So sort of going forward when the world opens up again, so to speak, do you think these spaces would be quite useful to continue?
Yeah, absolutely. I think that this is something that we need to continue, because for us from Brazil, we have highly we do not have any scholarships here. Our government is actually reducing them in the last year or so, and so we need to be in places at the global north like this. This is something that's highly good, highly welcome for us in the global south, and I think it should absolutely continue. It's for example, I'm intending to participate at the Hague Academy of International Law, and it was, for us, it was absolutely impossible to go because it's you need to be in the Netherlands for 15 days, and you have to pay a huge amount of money to submit. So now they have one for a quarter of the price, and you can be at home and study there. So it's I think it's a highly good thing. Yes.
Yeah, really interesting, and I think just really nice to know that even the current context has brought opportunities as well as difficult circumstances. So it's really nice to think about. Thank you. Question here from John for Colin. John mentions there's a lot of research going on in terms of identification of vulnerability in the criminal justice system. Obviously something that we heard from John himself earlier. Yet there are real systemic questions as to whether our adversarial model of criminal adjudication can properly deal with it. Do we need a root and branch overhaul? For example, maybe in your own area, is the current framework fit to deal with the issue of vulnerability? So I don't know if you have any thoughts on that, a lot on that question, but yeah, over to you, Gillian.
Point taken completely about the adversarial nature not necessarily being productive or positive, particularly in the criminal justice side of things. From direct provisions perspective, because disability is completely ignored, anything is going to be better than what's there now. And as awful as that attitude is in my response, the vulnerability assessment tool would be an actual huge opportunity to be able to have quality, best practice development of this assessment tool to actually identify people and access them, individual services and supports, and particularly around mental health in direct provision. There's so many areas that we could talk about the specifics, because each person's vulnerabilities will be so broad and their needs so different. So I think they're the conundrum is the same in both in lots of ways. The word vulnerability and disability, it causes such a lot of issues because we have to be really careful. But because it's a vulnerability assessment tool, we can't get away from the word vulnerability. Within disability law and CRPD language, we wouldn't use the word vulnerability intentionally. It's just like special needs, we wouldn't use that word. We use disabled person or person with disability. But in this case, with direct provision, the vulnerability assessment tool I see as a really great step in actually bringing disabled people to the table. Under the CRPD, if the language is used, it will also hopefully include talking to disabled asylum seekers themselves, because one of the central parts of the CRPD model would be that disabled persons themselves speak for themselves, and disabled persons organisations in Ireland have very little engagement at the moment with this as an issue, as is the case more broadly. Thank you.
Brilliant, thanks so much. We still have a little bit of time left, and then we'll be heading into a break. I just gonna take my position as chair to put a question to each of you. I'm just curious for each of our panelists. I mean, we've been talking a lot about addressing inequalities in various different fields of law, and I'm wondering if, in an ideal world, maybe what one step do you think is most important that could be taken in your area, or what you've discussed today, to move us to a position of away from inequality and towards equality? So big question, I know, but if there's one thing that comes to mind that you'd love to see change, what would that be? Just might be a nice way to finish up this panel. So I'll maybe go in reverse order and turn to Rayhana first.
Okay. Well, there's so many things that kind of needs to be incorporated, but I would say that I think the countries, the nations, and international forums, that need the governmental forums, all need to realize that climate change and inequality, or human rights and minority rights, whichever wording you might want to use, is very integrally linked, and there's no way that we can move forward to a sustainable future if we are not to actually develop an approach that sort of combines both of this and addresses all of it, because climate change affects the vulnerable groups first and most. So that's just something that needs to be done, which is not being done as much as it should be.
Thank you so much. And if I pass it over then to Colin.
Mine is probably a no-brainer. I would love for direct provision to be completely abolished, finally. And I think practically that could be a possibility for the first time with the Catherine Day report. The government is due to release a white paper based on that report. But the only thing is it will have to be adopted entirely, not in piecemeal parts for it to work. So that would be my wish and my hope. And I think there'll be huge celebrations. I also think Ireland can really be a great example and a leader in showing a change to how we are operating in our protection system within a European perspective as well, because it's really an area that, you know, we've had 21 years of it now. It's time for a change. Thank you.
Brilliant, thanks. And finally, Fabrizio.
It's a really huge question, isn't it?
Yeah, no pressure.
Yes, no pressure at all. So basically how we are going to resolve the problems of the world regarding inequality. Yes. So I think so that I come from a perspective of political philosophy. I like Hall's and the global justice theory that came after him. So I need to address the injustice or the structural injustice that are everywhere. So in my thesis, I intend to do that by regarding the access or the universalization of higher education here in Latin America or in the global South. And then I started to focus more on Brazil because we have here some measures to implement a broader access, because in terms of public universities here, it's the opposite of the global north. And here, the public universities are far better than the ones private. We have a lot of good privates as well, but we need to fully address the universalization of access to higher education. And I think so that this is a starting point and not at all the full question answered, but I think it's a starting point here in Brazil as well. Okay, thank you.
Brilliant. Thank you all very much for taking on that very large question. And I think we're just going to wrap up here now.
Can I just come in there?
Sorry, yes, go for it, Colin.
No, I've just really interesting discussion. It's just making me think here just before we, and just not really a question, but just a reflection on the theme, you know, of addressing inequalities. And listening to all the presentations made me wonder, just as an ongoing discussion point around that whole question around inclusion and participation, you know, like what was threaded through all the discussions I thought was really interesting is, first of all, the importance of affected communities being at the heart of any discussion. So, you know, I think number one, I think that's really important, that affected communities in whatever area we're thinking about in terms of inequalities are at the heart of the conversation. But I suppose the second point in terms of inequalities makes me wonder is that it's just a bit like this today, what we're doing, right, in this weird world of virtual. How do you create a system whereby people can participate or engage on a basis of equality? And, you know, listening to all the presentations made me wonder in all the different areas that we work in, you know, that what are the structural and other conditions? What are the sorts of things that we need to be in place, you know, to allow affected communities to be at the virtual or other table, you know? And the more, maybe this year, it's got me reflecting on equality and rights and how I think increasingly now, particularly around some of the activism that's putting affected communities at the heart of activism as well, that even for scholarship, there's something in that, you know, that what are the conditions that make, you know, participation effective, you know, and what are the rights that need to be secured and locked in and other things that And I just think that in all of that, there's something there about how we try and do something about this, locally or globally as well. That a lot of doctrinal legal scholarship misses or something, or doesn't. It's why I think, engaged, committed, critical legal scholarship begins to get at some of these things. I didn't mean to. I was going to just wander off there, the virtual then, but I just thought it was such a fascinating discussion, and there seemed to be, a thread flowing through everything. So that's my just thoughts in terms of that. But thank you. It was wonderful. Excellent. What a global conversation as well. So.
I know. Thank you so much. Really, really great to hear. I'm glad you popped in at the end to share that. I think a lot of food for thought. I feel like I need to go away and think about a lot of this, even in my own work. So really a lot of food for thought, and I'm sure the same for everyone. And all of us who are researching on rights and equality, there's just a lot to think about, and there's a lot to be done. So we need to keep going with that, virtually or otherwise.